socio-economic equality and justice. It tells us that environmental considerations are not only important for sustainable development, but are also necessary for us to holistically address the plight of the vulnerable in our society. This is so because evidently, those who lack access to food, water, sanitation, housing, and health care also often live in environments that are harmful to their health and well-being. The lesson that we must carry forward into the next decade as we celebrate these 10 years is that ELC must be at the forefront in championing a very progressive, social justice-oriented jurisprudence that ensures that we have a clean and healthy environment, an environment that protects the dignity of the people existing within it and enabling their well-being and enabling our communities to flourish. In addition, as we investigate our future and see how best we can navigate and make life better, we must appreciate that the new frontier in environmental governance is climate change. This is so as climate change is problematic. It has affected our environment and given us so many challenges. I can therefore speak like a prophet and say that the most complex and challenging disputes that will come to our courts in the next decade will not be those relating to presidential election disputes, as difficult as it was, or those regarding the constitutionality of the constitutional amendments, otherwise called BBI, as difficult as it is. What will play in our courts are the disputes which will deal with the adaptation and mitigation measures relating to climate change. And I hope, judges, you are hearing this so that you can gear yourself for very, very challenging times as you navigate this to protect our environment, as you navigate this to protect humanity for our own survival. Given that our commitment is to stay ahead of the times and to anticipate any complex issues that we are likely to encounter, I will be working closely with the Director, Kenyan Judiciary Academy, and the entire Academy, and also the Principal Judge of the ELC to work towards enhancing training programs for the ELC judges in matters relating to climate justice as a matter of extreme urgency. I've already started a conversation with Justice Benjamin to see how many of you can go to Brazil to go and see what they are doing there, nurturing their own indigenous jurisprudence and systems. The land dimension of the ELC jurisdiction concerns a question that goes to the root of state stability, social harmony, and peaceful coexistence of our nation. And this is why our Prime Cabinet Secretary, we have embraced court-annexed mediation. We have annexed these open days activities to have discussions with the people on how we can solve our own problems, how we can empower our own people to solve and find solutions for the problems of land that they are dealing with. The so-called land question has been one of the vexing concerns that is always blamed as the root cause of the numerous conflicts that we experience in our communities. If we can remove the land conflicts in our society, I think we can just talk of very peaceful and harmonious coexistence. Therefore, the Constitution vested the Environment and Land Court with a huge and demanding mandate, and you have been equal to the task. In collaboration with other institutions and actors in the land sector, like the Land Commission, we must all work together to ensure that we play our role in mitigating and resolving these complex land problems. We must appreciate that the constitutional promise of equitable, efficient, productive, and sustainable holding, use, and management of land is transformative, and it is one that promises to ensure that we maintain our environment and also our land governance system that is characterized by fairness, not dispossession, by protecting our public land from land grabbing and other injustices that have contributed to inequality and poverty in our nation. The land question continues to occupy a central place within the transformative imperative signaled in the Constitution. Transformation requires change both in the distribution pattern of property holdings and in how we approach the acquisition, use, transfer, and protection of the land rights. The court must therefore balance several demands. Justice Wanjara just alluded to our colonial period where we were dispossessed of our land, and from there we have never seen land justice. Therefore, the demands of collective justice and the requirements of economic growth and development in a country where land is a key factor of production and a means for the alleviation and the reduction of poverty are equally central. This court is expected to develop the jurisprudence that advances the goal of reversing the effects and legacy of injustices in the land sector, and also so that our social and economic development can progressively bring the changes and the prosperity that is expected. The court's impact on our society is to be assessed on how transformative and friendly the court's jurisprudence and access is and has been in the last 10 years. Going once more to mention what has been documented in the casebook, it highlights some of the landmark decisions the court has rendered in this decade. And I see an emergence of a jurisprudence that promotes constitutional goal of a land system characterized by improved security of tenure, equitable access to land, access to housing, protection from arbitrary evictions, protection of public land from grabbers, and arbitrary deprivation of property. All these cases are documented in your casebook, and they form a wonderful resource, especially for the lower courts and also for the higher courts. When we are determining issues of land, we look into it for guidance. I can say with confidence that there is already emerging from this court a line of thinking and an angle of approach to land jurisprudence that embraces and promotes social justice vision. This is the vision that we are implementing in the judiciary, which is drawn from the Constitution. 10 years of this court has therefore seen impressive progress in our land law jurisprudence, which is a steady foundation, and I encourage the court as we move to the second decade to build on that. One of the drivers of the court to create a specialized court for ELC matters was the perception that these disputes ought to be dealt with expeditiously. Kenyans felt and expressed themselves that the generous constitutional jurisdiction of the High Court was not amenable to the efficiency and focus that needed to be given to resolve the land disputes and conflicts satisfactorily. This means that re-engineering service delivery at the ELC for efficiency is a topic that must concern all of us as we debate and reflect on the past and the future. As we champion the vision, which aims at improved institutional performance and includes the interventions and innovations that we must employ under our vision, I encourage this conference to debate and come up with game-changing innovations and proposals that the court can adopt to ensure that it attains the vision of being a center of excellence in the delivery of environmental and land justice. I encourage the court to continuously work in pursuit of the target of ensuring that its operations provide an enabling environment that ensures our Kenyans get access to justice and also reinforces the integrity of court proceedings while enhancing the public trust in the judiciary. The court should continue in the path of optimizing its operations, the generation and use of high quality and reliable data to enable evidence-based decision-making, and leveraging on automation and digitization of its systems and processes to enhance our service delivery. As I conclude, I encourage the court to continue strengthening its ties with other avenues for dispute resolution in line with the statutory edicts that is provided under Section 20 of the Act that directs the court to use conciliation, mediation, and alternative traditional justice system in the resolution of disputes. Your Excellency the Governor, we have also agreed that we are going to start the alternative justice mediation suite here in Kilifi so that we can promote the mediation and the conversation with the people of Kilifi on how to resolve the land conflict here. Each one of us seated here this afternoon plays the role of one role or another in protecting the environment. That's why we are here, because we associate ourselves with what this court does, either for the land or for the environment. This is either through empowering one